This is the Thom Hartmann Program.
And welcome back. Thom Hartmann here with you. And on the line with us, Ian Milhiser, the editor of the Think Progress Justice blog over at the Center for American Progress, where he's a senior fellow with the Center for American Progress Action Fund. thinkprogress.org is the website. And he's got a new book out. It's called Injustices, the Supreme Court's History of Comforting the Comfortable and Afflicting the Afflicted. Ian, welcome back to the program.
It's great to be back. Thank you so much.
Great to have you with us. So tell us, just to begin, the Supreme Court's history of comforting the comfortable and afflicting the afflicted. I think a lot of people think that the Supreme Court actually saves us from crazy people, or from bigots, Brown versus Board of Education, or expands the rights of women, Roe v. Wade. Isn't the Supreme Court both don't they have a history of being both a conservative and a progressive force in America?
I certainly discuss the periods in my book where the Supreme Court has done the right thing, but one thing that I lay out is, first of all, those periods were extremely rare. So Brown v. Board of Education, on the day that the justices first convened to decide the Brown case, there were 3 votes to uphold segregation, and there were 2 justices who were on the fence. Of the justices who were present in the room, Justice Hugo Black wound up becoming a great proponent of civil rights, but you never would have guessed that from his resume because he was a member of the Ku Klux Klan before he became a justice. There are other people who were not in that room. Justice Jimmy Burns was the governor of South Carolina who hired the best lawyer in the country, literally the best, most experienced Supreme Court litigator in the country to defend Brown, or rather to defend segregation. That former governor had been on the court. He left after a year. If he had stayed, he would have been an almost certain vote in the wrong direction on Brown. Of course, we all know that Earl Warren, Chief Justice Warren, wrote the decision. Warren wasn't in the room. Warren got onto the court because Chief Justice Vinson died of a heart attack while the Brown case was pending. And President Eisenhower, I have some other choice quotes in here from Eisenhower that I can't repeat on the radio, but Eisenhower later said that putting Warren on the court was the biggest damn fool mistake he ever made. That's the quote I actually can say on the radio. So you will see that, even though we had this period where the court was doing a fair amount of good, less good than you would think, and I can get into that in a second, it happened because of a series of accidents, which are unlikely to repeat themselves again. And if you looked back on it, you never would have guessed, for example, that the justice who was in the Klan would wound up being a big supporter of desegregation. Right.
It's really quite remarkable. So the Supreme Court, starting in, if I can just kind of step into the Wayback Machine for a second and get this kind of out of the way. In 1803, in the Marbury case, the Supreme Court asserted their ability to, or their right to, strike down legislation passed by Congress.
That's right.
And Thomas Jefferson, who was president at the time, went nuts. And let me just read to you maybe 6 or 8 sentences that he wrote to his friend Spencer Roane, who was Patrick Henry's father-in-law, and the Chief Justice of the Virginia Supreme Court. He wrote, "If this opinion be sound, then indeed is our Constitution a fellow de se, legally a suicide. For intending to establish 3 departments, coordinate and independent, that they might check and balance one another, it has given, according to this opinion, to one of them alone the right to prescribe rules for the government of the others, and to that one branch, too, which is unelected by an independent of the nation. The Constitution, on this hypothesis, is a mere thing of wax in the hands of the judiciary, which they may twist and shape into any form they please." And then he goes on about how, absolute power is absolute and not a good thing. And he says, a judiciary independent of a king or executive alone is a good thing, but independent of the will of the nation is a solecism, a blunder, at least in a Republican government. How did that transition happen? How did we get to a Supreme Court that has become so activist? And why, I'm familiar with Andrew Jackson, pushing back and saying, yeah, good luck, trying to enforce the Trail of Tears thing. And Abraham Lincoln, for example, in the Dred Scott case, saying essentially that really should only apply to Dred Scott, that, the Supreme Court decisions need not be generalized. how did we get from a three coordinate branches of government to a Supreme Court that's running the show?
It's a good question. I mean, I don't necessarily have a problem with judicial review. You know, we have a written constitution, and I'm frequently very critical in the book of the times when the court has not followed our written constitution, when they allowed people to suppress dissent in World War I, when they repeatedly ignored the rights of African Americans that were written into the Constitution after the Civil War. So, you know, I do think that the court has an important job to do, but this court has wielded its power of judicial review terribly. You know, you mentioned that Marbury was the first decision to strike down a federal law. The second one was a little case called Dred Scott, which, of course, was a pro-slavery decision. We ratified 3 constitutional amendments to get rid of Dred Scott, and shortly after those amendments were ratified, there was a massacre in New Orleans. Not in New Orleans, in Louisiana. There was a contested election. The African-American Republicans figured that they could capture the courthouse in a local parish, and they thought if they occupied the courthouse, then they would control the government. And a white supremacist mob led by a former Confederate general marched into town and massacred the freedmen who were occupying this courthouse. The Supreme Court went on to say that African Americans, freed slaves at that point in history, had to look to the states in order to vindicate their rights. So these freedmen had to look to their state government to protect them from these white supremacist mobs. And of course, this was in the period when white supremacist mobs were becoming the governments of the southern states. Right. So, you know, the Supreme Court laid much of the groundwork for Jim Crow there. They finished that off with by upholding segregation. And then they spent 40 years doing things like striking down child labor laws, striking down minimum wage laws, striking down laws limiting, preventing workers from being overworked. During that period, they said that a woman could be sterilized against her will. And in the process, they ushered in an age of eugenics. And, you know, as I also discuss in Injustices, there are worrying signs that the current court is beginning to adopt the spirit of their predecessors.
Of the Lochner Court?
So certainly, I mean, the scariest case in my lifetime is pending before the court right now. This is this King v. Burwell case, which threatens to take health care away from millions of Americans. It's an attack on the Affordable Care Act. If it succeeds, an estimated 10,000 people will die every single year who otherwise would have lived. And the legal theory in this case would be a joke if there wasn't so much at stake. You know, I discuss in here what life was like for people in the United States before we had the Affordable Care Act. I discuss a woman who was raped, and she was told by the insurance companies that her rape was a pre-existing condition. She could not get health care. I discuss a family in there where there was the woman had a heart condition. Her husband was in a motorcycle accident, and they could afford to pay for her heart pills, or they could afford to treat his injuries. They could not afford to pay for both. Now, no human being should have to make that kind of decision, but certainly no American should have to make that kind of decision. The idea that in the wealthiest, most powerful nation that has ever existed, we are going to let people die from preventable medical causes because we just aren't generous enough to ensure that they get care, that is an abomination. And it is, I cannot imagine what would go through the justices' minds who are considering sending us back to that world in this King case.
So you're suggesting that basically King v. Burwell is a political case rather than a legal case?
I mean, there's certainly no legal basis for what the plaintiffs are arguing for.
Can you stick around for a bit?
Absolutely.
Okay, let's continue this conversation. We've got to take a quick bump out here. We'll be right back. It's 15 minutes past the hour here on the Thom Hartmann Program. We're talking with Ian Milhiser. His new book, Injustices, the Supreme Court's History of Comforting the Comfortable and Afflicting the Afflicted.
This is the Thom Hartmann Program.
And Ian writes, in fact, he's got a great piece up today over at thinkprogress.org. Ian, you still with us?
I still am.
Okay, great. In the New Republic, you write, never count on the Supreme Court to protect voting rights.
Mm-hmm. Oh, go ahead.
Well, I was going to say, I'm guessing most people think that the Supreme Court probably played a friendlier, benign role, at least post-Reconstruction, in voting rights, uninformed as they may be. But, I mean, what's the real story here?
Sure. So, I mean, the Supreme Court's history on voting rights has less been a story of bigotry at times than it's been a story of impotence. And what I mean by that is there were some very good decisions in the mid part of the 20th century trying to rein in Jim Crow excesses that prevented black people from voting. But the white supremacists were too nimble for the courts. The courts could strike down a poll tax and they just implement a literacy test. And the courts could strike down a literacy test and they just change the hours of the polling place. And the court would make them open up the polling place. And this was an actual tactic that white supremacists used. They would move the location of the place where people had to go to register, and they'd only tell the white people in town where it was. So what happened was, even though there was a period when the courts were trying to do the right thing on voting rights, they were unable to stop these tactics because courts can only enjoin something that is already in effect. They can't say, okay, hypothetically, if you pass this law in the future, you can't do that either. What stopped Jim Crow voting practices was the Voting Rights Act of 1965, which said that in states that have a history of voter suppression, all new voting laws are halted immediately until a federal official has a chance to review them. And that's what welcomed everyone in the South into the franchise. The day before the Voting Rights Act was signed, 7% of African Americans were registered to vote in Mississippi. 2 years later, 60% of African Americans were registered to vote. And it wasn't the courts who did that. It was Congress, by making sure there was a way to stop voting laws without having, or voter suppression laws without having to go through the courts. Of course, as you know, there's an epilogue to this story, and the epilogue is that just a few years ago, this Supreme Court, under Chief Justice Roberts, struck down that provision of the Voting Rights Act and killed the single most effective tool that the United States has in order to fight voter suppression laws.
Well, and the other epilogue would be look at all the voter suppression efforts that are continuing in the South. In particular, the you can't vote for the rest of your life if you're a felon laws, like in Florida. I believe just in the state of Florida, that's disenfranchised over 500,000 people.
That's right. I mean, as I said, the creativity of people who do not want certain people to vote has not ended. You see voter ID laws, which the Supreme Court struck down, despite the fact that they do nothing but prevent people from voting. The argument, or rather, the Supreme Court upheld, despite the fact that they do nothing but prevent people from voting. The argument you sometimes hear for voter ID laws is that they're needed to stop voter fraud at the polls. Voter fraud at the polls doesn't exist. There was a study of 3 million Wisconsin votes recently, which found that only 7 of those votes were the product of illegal voting, and none of those 7 votes would have been stopped by a voter ID law. So the entire case for blocking people's fundamental rights is fallacious, and the Supreme Court said states can do it anyway.
Yeah, it's Paul Wayrick stuff. I mean, it's amazing stuff. Hang on just a second, Ian. We've got to bump back out here. We'll be right back. It's the Thom Hartmann Program. We're talking with Ian Milhiser, his new book, Injustices, the Supreme Court's History of Comforting the Comfortable and Afflicting the Afflicted. After this. For the sane among us, welcome back. Thom Hartmann here with you. Ian Milhiser on the line with us, the editor at Think Progress Justice, thinkprogress.org, senior fellow with the Center for American Progress Action Fund, author of the new book, Injustices, the Supreme Court's History of Comforting the Comfortable and Afflicting the Afflicted. So we were talking before, a little earlier, about the King v. Burwell case being essentially a political case rather than a legal case. I think you could probably make a strong argument for Bush v. Gore in that category as well, and maybe a few others. In fact, I'm sure there's a lot of others. What do we do about that? It's
a difficult question, and the reason why it's a difficult question is that if we had a constitution that was more amenable to amendments, then there's lots of things that we could do. Alaska has a very interesting nonpartisan way of picking judges. In fact, they do such a good job of picking judges in a nonpartisan way that one of President Obama's appointees to the U.S. Court of Appeals for the Ninth Circuit was a Sarah Palin appointee to the Alaska Supreme Court. Wow. So there are models that work. That allow nonpartisan selection for judges. The problem is that to enforce them at the presidential level, you need a constitutional amendment, and the Constitution is very, very difficult to amend. Yeah. Absent a constitutional amendment, the single most important leverage point that people have is the ballot box. In this, when the next president is sworn in, there will be 3 justices who are over the age of 80, and one justice, Justice Breyer, will be coming up right behind them. He'll be 78 or 79. So the next president could appoint as many as 4 Supreme Court justices. If that president is inclined to take us back in the direction that you're hearing a lot of conservatives talk about, if he's inclined to move in the direction that if you attend the meetings of the Federalist Society, which is a very influential conservative legal group, where they want to take the law, they want to build the bridge back to the 19th century. And there's already one justice on the court who wants to do that. Justice Clarence Thomas has said that he would take us back to the era when child labor laws were struck down. Under Thomas's vision of the Constitution, we couldn't even have the ban on whites-only lunch counters. So if we get 4 more of him, and there are very powerful elements in this country that want that to happen, we are in for a wild ride. What is at stake is the entirety of the 20th century.
Yeah, yeah. The Civil War era I find fascinating. Mm-hmm. The Dred Scott decision, arguing that people are property. We have a mirror image of that in Citizens United, arguing that property is people. And I'm wondering, in your scholarship, in your history, learning, reading, mm-hmm. knowing, how far away from, it's not my sense that civil war is about to break out in the United States, right, as a shooting war kind of thing, but it is my sense that we are more divided certainly than I've ever seen in my lifetime. And how does that fit in the historical context?
Yeah, no, it's certainly true that we are an extremely divided nation right now. But as it turns out, our Constitution has a mechanism in mind for how we resolve our differences, and it's called an election. If we turned back the clock and Mitt Romney were president and he implemented the Ryan budget and all of a sudden Medicare was being phased out and people were losing their Medicaid benefits and all the other terrible things that Paul Ryan wanted to do, I wouldn't be happy with that. But that's our own fault that if something like that happens, because that would be the product of the choice that the nation made. What you are seeing more and more with the conservative approach to the Supreme Court, and you saw it throughout history with cotton mills suing to get child labor laws struck down and the like. What you're seeing more and more is that there are groups who don't have much confidence in the electoral process. And if they can win the battles that they are fighting in the Supreme Court, then they don't have to worry about what the American people want. I mean, ultimately, that's what the Supreme Court does. If the Supreme Court had struck down Obamacare, they would be saying that this entire thing that, should have been left up to the discretion of our elected officials is now off the table. And no matter who wins the election, we can't have it. And that should frighten everyone. If someday in the future we have a court that is much more liberal than the one we have now, I hope, and I'm serious about this, I hope that they don't behave like a bunch of liberal Justice Alitos, because, I think that democracy is very precious and that we should have a choice in how we are governed. And when anyone tries to take that away from the American people, it should be something that we find very frightening.
Yeah. Congress has the right under Article 3, Section 2 to regulate the Supreme Court. There are some tinkering around the edges regulations that a number of people have suggested over the years, allowing cameras, recording devices, making all their proceedings transparent and public, things like that. These are things Congress could do tomorrow to make the court at least a little more accountable / responsive. Thoughts?
I mean, I think that, Obviously, I cover the court for a living. It would be nice if I could do that from my desk. So I support cameras in the courtroom. I think that we should be realistic about the fact that these are people who serve for life, and they aren't really accountable to folks. So I think that there's a limit on what we can accomplish by shining a light on what the justices do. And I clerked on a federal court before. Most of the important work of a federal court, the oral arguments are often for show. Like the important work takes place in the judge's chambers. It takes place in letters that are exchanged back and forth amongst the judges or the Supreme Court, the justices. And for good reasons, those deliberations are not public. So I think it would be nice to have cameras in the courtroom, but I think we should be realistic about the fact that the problem with this court cuts a whole lot more. It cuts deeper than sunlight is going to shine.
If they were just subject to the Judicial Code of Conduct, right now, Alito and Scalia and Thomas would be, basically kicked off the bench for going to Koch brother events, wouldn't they?
I mean, I don't know if they'd be kicked off. I mean, the issue there is whether they're corrupt or whether they're ideologues. And I think ideologues are worse, because corrupt people, at least they stop doing a terrible thing when you cut off the spigot of money.
There you go. Ian Milhiser, it's a brilliant book. Thank you so much for dropping by, Ian.
Thank you.
It's great talking with you. The book is Injustices. Hang on just a second.
You're listening to the Thom Hartmann Program. Call 202-536-2370.
Ian Milhiser, Injustices, the Supreme Court's history of comforting the comfortable and afflicting the afflicted. You can read all about it also over at thinkprogress.org.